Make sure I can get your address in there, Marty.
It's 11:54, so it's still morning. Good morning.
Good morning.
Or he said, I don't know, we'll try. So I'm thrilled. We're gonna let him have a little bit of lunch. I'm gonna start you out. But I'm gonna start you out with our sponsor today of the lunch, CNB Bank. And if you don't know, you know, I have a little affiliation with this bank. I sit on their board of directors for 22 years. So these are good guys, as our stockholders know. All right. We're here today to talk about the Contingencies Addendum. And the reason we're talking about it is at an education meeting a month ago, we had a prominent associate broker who said, you know, I just don't quite know what y'all people trying to do with that contingencies. I just don't get it all. And so as I've been teaching it as basic contract and advanced contract, we decided that, well, maybe we ought to try to have some discussion about this contingencies. And part of my reason for being here is that I'm on the forms committee. I do not chair it any longer. If you have a complaint, Chris Boris at pearsonsmith.com will take your email. But what I try to do is at least be present so I can hear the discussion, hear the reasoning behind this, and basically as I incorporate it into my contract classes, kind of give you guys some insight on what we're dealing with. Long story short, the Contingencies Addendum, as it was rewritten, okay, what we attempted to do was to try to gather all of the inspection contingencies together at the beginning of this addendum, and then obviously work through any of the other possible contingencies that a transaction might have. I just yesterday had a complaint from an agent who called me up and said, where's the terminating residential sales agreement? And I'm like, well, it's not there. And she's like, well, why is it not there? I'm like, it's not there because it's on the Contingencies Addendum with the inspections. And she's like, well, you know, I think I marked my contract that there were no inspections on this property. I said, I think you did too. I said, show me your documents. She did. I said, I think you did too. And she said, but I want a termite. I said, too late. You know, the reality, and she was representing the buyer. I said, you know, the buyer can do a termite, but the reality of what you're doing is it's not in the agreement. The place where we work on what inspections are going to happen is in the Contingencies Addendum, and you have a brand new draft with you today that will be released in July of this year. Okay, and again, we're just trying to make the point that you guys understand. You'll see where the red paragraph is. Above it, it says this contract is contingent upon home inspections and any other inspections, and there would be an addendum attached. Or the purchaser accepts the property in as-is condition without inspections or contingencies. One of the things that happened at the beginning of adding as-is with no inspections to the Contingencies Addendum was that agents continued to use that as, I'm not doing a home inspection, but I want a well and a septic and a termite and every other inspection that I can think of. Right. That's not the way this document read. This document read originally, if you were doing any inspections, you don't waive off. And it will continue to say that. If you're not doing any inspections, you will waive off. Okay? Now, it doesn't mean, and I told the agent yesterday, it doesn't mean she can't do a buyer termite, unless the seller won't give them access to the house. But we had to separate out that when a buyer waives on any inspections, you cannot, in this Contingencies Addendum, go back and start willy-nilly adding inspections because well, septic, termite, radon talk about negotiating remediation. Well, septic, termite say seller will remediate. Okay, that's a contingency. That's a contingency. So you really want to think about if my buyer is waiving off on all inspections, that's what they're doing. They're not asking the seller for any remediation. Does that make sense to you? Shake your head yes, if it does. Wonderful, we're just batting 1,000 already. Okay, when you go to the contingencies, and the agent yesterday, she was a real good case in point. I was happy, because I was like, man, I got ammunition for them all. Okay, she goes to the contingencies and she's like, well, I didn't even use this document. I'm like, I know you didn't. I'm looking at your contract. I know you didn't. And she's like, well, they waived off. And I said, indeed they did. And in a technical sense, do I think it's good policy for an agent to, if they waive off on the residential sales agreement, to say I'm not using the contingencies? Maybe. But the reality is, I love the top of that contingencies addendum that says, as is without any inspections. Okay? The reality is that reinforces again, they're not doing any inspections. And you'll see in the bold above that, by selecting 1A or 1B, the seller is relieved of any inspection remediation requirement. So the bottom line is, the seller doesn't have to do that. Now I'm really going to confuse you, because it's happened to me, okay? Buyer doesn't waive off. They says, well, we're going to have as is with any inspections and right to terminate. And they do an inspection, and what do they find?
Mold.
Mold. Okay? The reality, Dave, that's scary. I represented the buyer. And I went back to the buyer and I said, you know, you wrote in as is with right to terminate. What do you want to do?
Right.
And the buyer said, well, I think, and it was not mold, it was suspect material. Okay? And the buyer said, I'd like to know if it's mold. I said, well, then we got to go back and ask for more time, because we don't have time left. So we went back, we asked the seller, said, would you give us more time? The home inspection has revealed suspect material. Will you extend? In writing, not by a text. Did you hear that? Shake your head yes. Okay. The seller gave the permission. What do you think happened? Oh yeah, it's mold. This property is 10 years old. And the basement is, the crawl space got mold. The buyer came back and said, well, you know, and I said, you've basically written an offer that says as is with right to terminate. Do you wish to terminate? And the buyer said, well, I really want this house. And I'm like, well, I think you got two choices. Actually, probably three. I said, your release. He said, I don't want to do that. I said, okay. You take it as is. He said, wow, I don't know how to do that. And I said, well, if you're going to ask them to do work, then the ammunition for you to ask them to do work is, I've revealed a latent material defect about your house. What will you do, Mr. Seller? And it worked. And it was the truth. Was it the truth? Is that a latent material defect? Yes. And did the listing agent have to say to the seller, if the buyer waives off and releases, we got to disclose it? Shake your head yes. You have to disclose once you identify it as mold. Can you sell it anyway? Every day, all day long, as long as everybody knows what's going on. Does that make sense to you? Yeah. Now, I get agents who call me all the time, mine, yours, everybody call me all the time and say, well, they did that as is with right to terminate on the inspections, but, you know, there were a couple nail pops, and, you know, there was some GFI missing, and, you know, they really wanted some stuff. Seller's decision. You know, very frankly, and I say this in class all the time, we negotiated an offer this past year when things were, and none of the offers had a home inspection contingency. The morning after ratification, a buyer presents a home inspection contingency. Went to the seller, said, okay, this is what they've asked for. They reopened negotiation, this is what they've asked for. And the seller said, but they said they weren't doing a home inspection. I'm like, West Virginia Real Estate Commission says I have to present every addendum and offer to you that I have, and that's just been handed to our company. And the seller said, well, what can I do? I said, you have two choices. You can allow the home inspection, or you can release. We were 1 day in. Now, I didn't say to the seller, and you guys know me well enough, and I've taught you all, that I hate to deny any buyer an inspection. I hate that. Right? I know I taught a lot of you principles. But the seller made the decision. She said, I'm going to release. I said, all right, then we're going to take 2 documents back. We're going to take a release of that contract, or we're going to take an addendum that scratches out that home inspection and is initial. What do you think happened?
They changed their mind about doing the inspection.
The buyer decided they'd buy it anyway. Who made that decision?
The buyer
The
and the
seller. The seller made the decision on what am I going to do about that. So the reality of all of these inspections, guys, is the matchup that I see, and I'm not the attorney, we're going to rely on Dave on this. But as you're looking at this document from the residential sales contract that says, I'm not doing anything, okay, and a contingencies that maybe says, well, I'm releasing on the home inspection, which is 2A, okay, with right to terminate, but I'm going to do all these other things. Is that any inspections? Yes, it is. So the reality is, if you mark no inspections, then you're not doing any inspection. Is that correct? Yeah. So I know it's a lot. Listen, I even had my guys say when I presented this, qualified. That's different. The seller
She's talking
gets to
about
make
crossing
that
off
choice.
the.
No, I understand. I understand what she's talking about. But the reality is, if you have a live offer and you've made those crossouts and it's not presented, you need to ask for verification, because the code will allow you to do that.
But if I'm writing the offer and my buyer says, I don't want a radon test, and I cross through that, how is that practicing law?
That's a Dave question.
Well, you probably anything is practicing law. Just as I probably practice medicine a good bit. I think you have a migraine, this is what I would take. I think you might have COVID. So, I mean, it's a straddling fence all the time. I mean, it's not uncommon to see that's done. I don't think your intent is to be practicing law, so I think you're probably in a safe harbor. I think it's just everybody practices a little bit differently, so there can be some confusion. So, it's a communication thing between the agents that might be involved that, and I know exactly what you're talking about.
Sure.
A big X,
Yeah, 'cause
and
you
to
see
me,
it
it's
on
like,
the
oh, we
contract.
read that and we don't want it.
That doesn't
We read it
happen.
and we don't want it.
Yeah.
Now, this thing here solves a lot of that, because if you go with 1A or B, you guys shouldn't be digging any deeper.
Yeah.
That's exactly
And
right.
if you start digging deeper, then you might have some confusion.
Yeah. And then 1A or 1B wouldn't apply. You jump right down to 2A, B, or
Right.
any, or C, D, E, F, G.
But when you're sitting down with the buyer and you say, Mrs. Jones or Mr. Jones, do you accept this property as is or not on page 1? And then you start talking about, well, what contingencies are available to me? And by the time you get back here to page 2 and 3, they've kind of changed their mind. And they've said, we kind of changed our mind. We've talked a little bit while you went to the restroom, and we want a radon test. And so now you got to go back to page 1. You got to change all of that, and now you're back to radon. And with electronic documents, it makes it even more confusing.
Oh, for sure.
Because it automatically plugs those
You gotta take those out, yeah.
those initials in, and then by the time the document is finished and ready to send to the listing agent, you've got initials all over the place. And I know electronic is today's world, but that's how we get initials on these contingencies that aren't supposed to be there. We use dot loop, and depending on how our documents are put in for our company, it automatically puts initials spaces. You either have to go back and remove them, and so that's the reason I kind of cross out those things. Is this is not part of the contract. It's crossed out. It's very clear. It doesn't
Let me make
apply.
one suggestion, and this is probably more pragmatic than law, is when you procure your prospective purchaser, especially when you procure your prospective purchaser, give them this. I mean, you can give them the whole contract, but just like in a closing, probably 80% of that whole contract is mumbo jumbo they don't need. But this is something you might give them and say, I want you to take this home tonight, and I want you to read it, because we're in a fast and furious market, and you're going to be asked to make a choice, and I'm not going to have time to mess around with you thinking over it now. Take this home and explain to them real quickly, A or B. If you want to go A or B, it's easy. You don't need to go deeper. But if you want to consider the deeper, take this home and look at it now, so that we don't have to, read the whole thing and then, thinking about it more. So just, a lot of this is market condition. With the market is the way it is. When this market slows down, everybody's going to have plenty of time to think.
That's for sure.
But I'm just thinking, listen, and I made that comment based on listening to everybody, and I know the fast and furious, the adrenaline's rolling, and then the worst darn thing is, I'm going on a vacation and you won't be able to get a hold of me, but by God, you gotta have this contract for me in 35 seconds or I'm never gonna like you again. I mean, that type of pressure, so if you can give them something in advance, that still won't calm them down, but at least you'll know in your heart, I was ahead of the curve, they saw this thing, so we need to move fast. What do you choose, 1A or B, or are we gonna go to the second stage where we're gonna pick a few things that the seller may have to remedy?
The other thing that I would say to you is if you do that, somewhere in your file or your notes or anything that the West Virginia Real Estate Commission or an E&O litigator might be able to pull, is make sure that you indicate. You actually pass that to the consumer in advance of their offer, okay? If I were sitting on a jury and I knew that, I would feel a little differently about the choices that the buyer made, okay? And please understand, if you get into court, into litigation with any of this stuff, they're going to pull every text, every email, every paper document. And if you've even kept a note that said, well, that I passed them the contingencies list, they decline having any inspections. I think it's some protection for you. And I'm really about protection.
Well, judges, again, we don't want to get there, and rarely are you going to get there, but there's a few people probably have been in court and not even that they were the wrong person. If you're the agent and the buyer and seller starts fighting, you're going to follow that case the whole way through, and eventually somebody's going to try to make you the scapegoat, even though you're not the wrong person. When people get backed into a corner, they'll start telling lies and they'll make up stories and stuff. If you get to the judge, and obviously sometimes you don't want to get there, but the judge may ask questions like, what is your common standard operating procedures? And that can only be attested to by, you may have to bring in a couple of people who did work for before and says, we got this stuff in advance. This agent's perfect, I don't even think anybody's ever going to get there in this room. And then for me, I make plenty of mistakes, guys, but I can tell everybody, I come to work sober, I come to work prepared.
Hold on.
I'm energetic. And so if nothing else, if I'm called to task, I can say, I may have made a mistake, but there was usually a rational basis behind that mistake. One of those rational bases is, you must have forced me into this. Like I've been called out a few times and I'll pull the phone, I'll look. Closed on the 31st of the month. It closed on a Friday. It closed with a power of attorney. All three things I would say don't do. So somebody bullied that closing in, and this is just me, and again, it doesn't solve anything, the problem's still there, but at least I have peace of mind that there's rational basis when there's a bad decision made, that I don't make bad decisions based on lack of effort or lack of a brain or some sort of lack of sleep or intoxication or something.
Or just because you were going on vacation, you had to get it done.
Yeah, and there could be factors in my life.
Yeah.
I get a phone call, mom's going to the hospital.
Yeah, absolutely.
And I'd probably come back to work that same day. I'd get a phone call like I just got.
Yeah.
Put you in the corner, you make decisions.
Yeah.
But if you're making decisions with reasonable efforts, and I think one of the reasonable efforts is maybe getting this thing out there early on, especially while it's, pretty fresh. And again, I know if you can do everything in a vacuum, it's always great, but the vacuum just evaporates rapidly.
Sure.
I do.
Go ahead, I'm sorry.
Okay, Anna.
So maybe when we go on a showing and we think they're gonna write, just bring these with us and say, here's this, once you guys read it and think about calling me up for an offer.
And the other thing that I don't think you have to go into a dissertation about what this does. I think what you can say is, Mr. Buyer, 1A and B says you're not going to do any inspections, you're buying it as is. 1B says as is of any inspections you do, and they'll give you a length of time to do them. 2 says I'm going to do some inspections, and there is an as is with right to terminate on just the home inspection. But the reality is that kind of talks about maybe you'll want the seller to do something.
Yeah.
Okay, and that's how those work. Kim.
Anna, instead of when you go on a showing, when you first meet with your buyer, give it to them then. That way they can review it, they can ask questions,
Yeah.
especially if you have a first-time buyer.
I do have like a file. I
They
give
can
them
do their own
information.
homework about whether or not they want the inspections. And then, when they're going on the showing, they can already have in the back of their mind, with this house, which inspections am I gonna want?
Now, the other thing that the agent yesterday came up with, which I thought was crazy. But anyway, she said, well, why would I want to use that 7-page document when all I want is a wood destroying insect report? And I'm like, well, I've seen some agents actually take page 4 of 7, mark that out, and say page 1 of 1. And you would mark the wood destroying insect report and you would initial. Your broker would let you know if they will let you do that. Okay? Now, as a broker, what I don't want is an addendum that's typed in there that says, buyer's going to do a termite inspection. That doesn't address remediation. That doesn't address anything. The reality is, that's the piece, and that's why we sort of took it out of the residential sales agreement, because invariably you would mark no on the residential sales agreement, then on contingencies you mark yes. Like, well, what do we do now? So we've tried to eliminate some things in the sales agreement and direct you to the inspections pages.
Great move.
Thank you.
I just want to make sure I'm clear. If I have a buyer and all they want to do is a termite inspection, that's the only thing. They would initial at 2 for individual inspections and
Yep.
then initial only at
F.
Perfect.
And they would sign it.
Only
Yeah.
if they were signaling that they would want the seller to
To
pay
remediate.
for remediation.
That's an excellent point, Patty.
If they,
Yeah,
they
excellent
can
point.
do it.
They can do an inspection themselves.
Right.
Okay, they could say 1B as is with any inspections and right to terminate. They do an termite inspection in a period of time. And very frankly, one of the ways we got this as is with right to terminate on any inspections was obviously we adopted the wording from the Northern Virginia Association of Realtors. They don't really know about well and septic inspections. Okay, there are lots of inspections that they don't necessarily have in Northern Virginia in an urban area that we have out here. In Winchester, all of my Winchester friends in Virginia, I don't know if it's total Virginia, but I know it's the Winchester area. You guys like the well and septic with the distribution box dug up.
Correct.
Okay, in West Virginia, that's completely uncommon, and I haven't actually found a vendor yet who'll do it. Now, if you have a vendor, that's great. And what the vendors have told me is we don't do it because every time we dig it up, we break it up. So we're not doing that. So does that make sense? No.
So, quick two
Okay.
questions. So, as a listing agent, if I get an offer that has 1A or B checked off, and they go in and they start
Checking stuff.
Right,
Checking
right on test, whatever. As a listing agent, present all offers, but it would be appropriate then to line through the 2C radon testing or whatever, have my guy initial it, send it back.
And this would be my question for the attorney. Is that a counteroffer?
Yeah, I say so.
I mean, it's almost as soon as they mark 2, they've kind of destroyed 1A and B. So, I mean, really, you've got a question. I don't think we can.
I agree
A
that that
judge
would
would
be
have to
a
answer, but I think a
counteroffer.
judge would say, you've just contradicted yourself in what you want to do, so that one result could be that 1A and B just doesn't exist.
That's where I find I go back to the agent who wrote the contract and I say, can you please clarify?
Yeah.
You're giving me 2 different signals. You want it as is with right to terminate, or do you want a radon?
But I want it
What-
in writing.
Exactly. So once they tell me that I presented it that way, and then that's the way we go back.
Change the document.
You know,
So it's almost to me, if you present
have
this
an
to the
initial.
seller, and the seller says, I'm okay with this here, then I'm not so sure this is even applicable now.
But I would mark it out.
Then you can mark it.
Yeah, then if indeed the seller is acceptable to do a well and a septic and a termite inspection, okay, and is acceptable that they will do the remediation, then I still would mark out 1A or B, because the reality is, if that's checked, my opinion, not an attorney opinion, but my opinion is, it's in conflict. You gotta lessen conflict in a document.
What do you
I
think,
think
Ken?
the big thing that comes with this 1B, if you're working for your buyer, they can do any inspections in there, but the seller is not going to do any kind of mitigation, any repair back. So they'll say, but I want radon and I want this. I said, you tell them, you can do it. You can have the electrician and the plumber within that period of time, but the seller is not going to do anything for you. The only thing you get is the right to terminate. I think that's where we get lost in what we're seeing when they're marking in these other boxes. We don't understand it.
I agree. Dave asked him a question. Yeah.
Well, and to piggyback off what she said, I can understand where the buyer is saying, okay, I want my termite, I want my well, I want my septic, and I want right to do other inspections without remediation.
right.
So in this case, this addendum doesn't provide you with that option.
Yes.
And we run into that.
Yeah,
We definitely run into
2A is the home inspection with right to terminate.
Yeah, but
Okay.
what if you also want a radon and a mold inspection with right to terminate, and in other words, if you want a blanket right to inspect, but the only ones you want a remediation on are the well, the septic, and the termite.
Okay, then I would mark, I would initial it 2, okay? I would initial it 2A, okay? And then I would roll right back to private well and septic, and I would initial it E,
yeah.
okay?
Well, what
So
about C and D? Because you also want a radon and a mold.
then I would initial, if you wanted radon, I would initial there, because the home inspection is not necessarily a radon inspection. It may or may not be, so I don't think you can blanket say that's what that is. But 2A is the home inspection with right to terminate. Am I correct?
Yeah, that.
But what she's saying is the buyer doesn't care about the radon, they want to do it, but they don't want the seller to mitigate, correct?
Right.
Is that what you're saying? And there is no option for that. If there's like a
Dear
few they
Lord,
want,
you
and a
want us
few
to
they
give
don't.
another block there to add that? No way.
Well, I mean, we
You
may
know, I
have
think
to.
what you, as,
Well, I think that would be back to 1B, and then you can do any inspection if you don't want remediation. 1B,
I think what she's saying is some they wanted remediation and some
yeah,
they
and then
didn't.
you go to 2A, and then your subsets off at 2A.
I'm gonna ask if Dave's looking at this document. Dave, if they wanted the radon, but they didn't care about negotiation of it, could they mark out, okay, the paragraphs that talk about the negotiation and initial beside of it?
I think you could, I mean, I think that would be good enough, but why
So,
couldn't we
Dave,
just?
can I say something about that? West Virginia appears to be different than every other state I'm licensed in, but every other state, yeah. But I have always heard from real estate commissions, attorneys, that these are approved forms the way they are, and to strike that language, and I hear you what you're saying, Dave, the intent and all of that, but what I've always been taught in my 20 years at this is that if you're striking that language, you are practicing law without a license, which none of us are permitted to do, because the language was approved by the state, the commission, our boards, etc., and that we should not be striking it, because what if you strike the wrong thing?
Okay,
right?
I personally wouldn't qualify that as practicing law, personally.
and the second thing I will tell you is this document is not approved by the West Virginia Real Estate Commission. West Virginia Real Estate Commission doesn't approve any
The only
documents
document
except your
is notice of agency.
That's it. And the federal government approves your lead-based paint at the EPA level, okay? But West Virginia has no blanket documents statewide, okay?
So as long as you have your NOA, you could write your sales contract on a napkin, and it would be sufficient in the state of West Virginia as long as everybody
To
agrees.
practice, that's
Yes.
correct.
And you also are obligated to present it.
Which is much different than other states.
Yeah, like every
that-
state. I don't know, I guess for our own protection, I would always tell people that, work for me that don't strike language. Work with the language that's there, don't strike language, and write as little of your own language as possible.
Okay, we have a
And
question.
I would agree with 100% of that, but I get people coming to closing that want to change my deed, and want to change the deed of trust.
Yeah.
And that is practicing law. And so it just, to me, it would see it inherently people, I don't disagree, that the more you can keep this pure,
The same.
it is absolutely the preferred. But I can see situations where people are like, I want that X out there. It's like,
I would say in your case that I would mark the contract the right way and then do an addendum that says buyer does not expect remediation on A, B, and C.
After the inspection comes in.
Right.
We have a question.
But if the buyer doesn't expect remediation, they don't have to use,
Well, she's saying that some they wanted and some they didn't.
which is why you would use 2A and any other
Right.
inspections if they wanted remediation.
Okay, we have a question up here. Hold up.
So the example you gave earlier, where the seller had some options when it wasn't filled out right. He did 1A and then 2B, whatever was also filled out. The seller could move forward. You gave him 3 options. Move forward, say no.
Take as is, release, take as, or to do the work. Let's rebuild a latent material defect.
Now, so I'm thinking in a slower market, may not be a big issue in this market, but in a slower market, the seller may want to hold that person to that contract, so that would be important.
Well, and that's exactly what Dave said. Dave said in a market that's different, probably 1A, 1B, 2A, 2B would be used at all. But in a market like we're in, and this, I'm giving an opinion too, but I'm giving a broker opinion, okay? My broker opinion is I would advise the seller what the options were, but I would say to the seller, please understand, you are making the choices, I am not. Put the client in the driver's seat. And let me tell you what, guys, if you do that, there's much less splashback on you. Put the client in the driver's. I was worried sick for the seller that had the home inspection addendum a day after ratification, because I was like, oh man. And we just said, okay, this is the choices. Ms. Seller, you can agree to the addendum or release. We will ask for release if that is your desire. And she said, I'll sign the release. I'm not allowing the home inspection. That's why I took this offer.
Right.
So, she could have sued me. I'm not telling you she couldn't. That in court will sue me. But the reality was, we absolutely in the file recorded that the seller was presented these options and that's the option she chose. Does that make sense to you? Anything else for Dave, because I know he's on the clock.
yeah, and this stuff always boils down to people. And so when you get a client, whether it's the buyer or if you're getting a listing, just hammering out the expectations, what is your goals? I mean, it's like investing in the stock market. I mean, people have different goals and different tolerance levels. And there are some people that probably could never buy a house unless every contingency was done. And you need to know that going in so that you can properly tell them. You understand we will probably be looking for a house for the next 2 years because the sellers are in the catbird seat. But you have to be at peace of mind, and that means to be part of your operating procedures and to become known as the person or people. I hope that's everybody. And again, I know you don't have a zillion hours to spend on it, but just, who are you? What do you do? What's your expectations? You know yourself. What can you tolerate? Do you want to buy a penny stock or do you want to buy, Apple? We know what Apple's going to do.
Berkshire Hathaway.
So, do you want predictability or do you want to get in the fast lane? Obviously, A and B is the fast lane. And right now, everybody almost has to be in the fast lane if they're going to dance.
Sad.
And it's tough. But again, this conversation's great. And I think everybody's got wonderful, wonderful ideas. And
I so appreciate you coming.
Yes.
today.
well,
I
you
put
got
him,
Kim down there too.
I put him on the hot seat. Kim had already said to me, I'm gonna be there. If Dave's not gonna be able to come in, I'll be there. I appreciate him too. Kim actually was on the education committee, so she kind of
I learned a lot as well. And thanks for having me as always.
Guys, something that Dave won't tell you is when we make some of these changes on these documents, I'll call Dave and say, hey, there's an email in the inbox and I want you to look at what we're trying to do. What do you think about this? And Dave's like, okay, this works, maybe this doesn't work. So the reality is, the reality is always helpful. Kim is always helpful when we're trying to make some of these things work. Tracy was for the first time in a long time at the Forms Committee meeting this week, and she's like, huh, okay. So the reality.
Right in and made trouble, didn't she?
Yeah, she did. She immediately. Who let her in here? Let her in. But the reality is Dave's right, and I think both brokers were right. Yes, communication is a big deal. But the other piece that I think that you always want to remember is that while you're trying I think it would be wonderful to talk to the other broker and find out what they really meant when they marked the document wrong. If they will call you back. Okay? I'm sorry, I'm going to put you on the hot seat. I call people all the time that never call me back. Now, guess what? When the gas company was shutting off the gas to a property that was 22 degrees, so I got a call back. So the reality is, I think communication is extremely important, but I want you always to remember who you represent. And you represent yourself. You don't represent the buyer. Yes, DK.
So just to piggyback off that real fast, 1B, I think we need to make sure that we cascade to our sellers that this actually opens Pandora's box from a sense of liability that could happen. Because they could have any inspection. And we can pry that information out of anybody all day, but they're not obliged to give us that information. So
I've had some agents say to me, if they were competing, they marked 1B and then they said what inspections they were going to do.
That's, I think, better.
That's a wonderful way for you to compete, to tell a seller, hey, I've marked 1B, but this is the only inspections I'm going to do. But you don't go back and mark them on the document.
right, but as a seller, when you look at that, what if they find any inspections? Well, any inspections, think of the amount of latent defects that can be discovered at that point, and then your seller thinks, oh, well, they had no intent to remediate, but
And
now
very
I have
frankly, the one that I used as an example was the only thing we were doing was a termite and a home inspection. And it still would be. So it, just as sure as we think it can't go wrong, it does. So, yes, Tracy.
Is it on the agenda at all to talk about the home sale contingencies? Not home sale, home sale, the way that's written?
No, it is not here, at the Forms Committee. Tell me what you think.
No, I just need a refresher on how to write it. To be quite honest, it's been a while. Like, what do we mark when?
Well,
if we don't have time, it's okay.
Well,
I'll point
let's take a couple minutes, okay? Let's take a couple minutes. The reality is, I think how you mark it is gonna depend on if the property's on the market, if the property's under contract, if the property is scheduled for closing, okay? So I think if you're not in a multiple offer situation as a buy-side agent, okay, as a buy-side agent, and maybe I didn't expect I was gonna be in a multiple offer situation, I might very well say, well, I just want a contingent on for sale and settlement of that property. Now, as a listing agent, I'm gonna come back to you and say, I'm gonna have my seller initial that. Because your property, your property might be under contract or whatever, or maybe it's not on the market. If it's not on the market, then I want to know there's a kick out. Okay? The coinciding settlements, the way that I've done it, doesn't make it right or wrong, just makes how I've done it, is I've started out with the kick out, okay? And then as the other contract actually had no contingency except financing, I've marked that out at everyone initial, and I've taken it over to coinciding settlements. Okay? Now again, that doesn't make it right or wrong, it's just the way that I've done it. Okay? The other thing that I think, you want to talk about on the sale or purchase of property and kick out is, the addition this last year that nobody really talks much about is as you're looking at page 4 and you go down to A, in bold it says, this contract shall remain contingent on the settlement of the seller's property, so you really don't have to move it to coinciding settlements. But I've just always done that because in the sense of full disclosure, I want everybody to know where we were in the process. Doesn't make it right or wrong.
Do you agree with marking 3? It's on the market, it's got a kick out.
Okay.
And marking 5 at the same time when you submit the offer, because when that kick out's removed and we move forward, we're going to be coinciding.
You could, yeah. I think it could
So
work.
basically, we
Yeah.
wanted both things to apply.
I think it could work.
That's how I've always done it.
Yeah, and I think
I
that
see
works.
that coming through
Yeah,
like that.
I think
so.
that works. Yeah, and realistically, that's really, A already says it's contingent until the settlement of the property. But by marking coinciding, if really and truly, if you are to the point where that property, that contingent property has a contract and it's ready to go, the kick out, the reason that I like to take the kick out is I want everybody to be clear that we're going to closing.
Yeah.
And how do you do that?
What do you mean?
Is there a document?
There is not a separate document,
Okay.
there's not. And I will tell you, my personal favorite is marking it out on this document rather than writing an addendum. Because I think when you write an addendum, you put in words you don't need or words you don't put in words you do need. And if you're using this document, you're just marking out. It's no longer a kick out.
And you just scratch through it.
I scratch through it, have everybody initial.
Initial.
That's just me.
Okay.
Talk to you.
And I would
Talk
assume,
to yourself.
yeah.
You're the pro.
And I would have,
scratch through 3 then. When you say you mark it out, you're
I just
you're
mark it out,
marking
the
through
kick
3.
out no longer applies.
Do you
now we
put a
go to
date?
coinciding.
Yeah, and date it.
And
sure.
date it.
Well,
That-
particularly if you're using electronics, it's already dated.
well, but I'm like Charlotte. I do old school.
Yeah, and
That's
the
the way
one
I
thing-
was taught. That's the way I do it.
Okay, if we're gonna open up more discussion, the other 2 areas I want to direct you to is number 7 on page 6, backup contract. I know nobody wants to hold a backup, but I've seen number 7 used absolutely in a great way. It's wonderful wording. The buyer is not obligated till they're primary.
Right.
Right.
So don't, I see agents all the time just go write an addendum, this is a backup contract. What's that mean? What's that
And the
mean?
EMD should be deposited at the time that backup
It
contract, because
indeed
it's
is
a ratified
always alive,
contract.
when it's
Okay,
ratified
just had
and
this
it's
the other
received.
day.
Yep.
And that's what
And
I
the
like
other
to
thing
do.
that I'll call your attention to is, let me find it. I gotta find it. Where is seller? Seller wants to, seller purchasing another property, page 5, number 6. There's been huge discussions at the forms level that they wanted to input a number in there, and the number they wanted to input was 60 days.
Oh my God.
And I'm like, no. And somebody said, well, I put 60 days in there all the time. I'm like, well, I don't think you're doing it with my sellers, you're doing that. Because I'm not going to let my seller on the hook for them to find, or my buyer on the hook for them to find a house for 60 days. That buyer is making some financial obligations. I think 7 or 10 or 14 days is appropriate.
Really?
But that's my opinion. Talk to your broker about it. I've seen lots of them go to closing that said 60 days.
A lot of them say 60.
I think it's also important if it's financing, you need to make sure your buyer talks to your lender.
Sure.
Because some lenders will not approve a
Right.
60-day rate.
No,
Especially with rates
Particularly right
climbing.
now.
Yeah.
Particularly right now.
yeah.
So, you know, guys, I guess, you know, your seller can say, I'll take a 60-day, or your buyer, sorry. Your buyer can say, well, I'll take a 60-day contingency on them finding a house. I'm telling you, I wouldn't let my son do it because he's living with me in the meantime. No way. Questions
Yeah,
about that?
but there again, you might have a buyer who doesn't have a short timeline.
Yeah, well, he would tell you he doesn't, but I would tell you he does. Just so you know.
That's right.
But, you know, that's another thing that's kind of a pitfall in these documents. And actually, we never used that till we got into this market.
Yeah.
And then to try to get sellers on the market, we said, hey, we'll give you some time to find a house. You know, and if you say to the seller, well, we're going to give you 60 days, then how much time are they going to take? 60 days.
And then they can't find anything.
Yeah, and then they're going to say to the buyer, sorry, too
Then you
sorry.
got- yeah, you got 2 months
bad,
past.
too sad. So be alert, guys. I think it's wonderful information here today. I appreciate, listen, anything that I tell you is my opinion. It doesn't mean anything. You know, I do have a direct line to Dave, I will tell you that. And be alert, because in July this year, we will upload the new residential sales contract that is a combination of the residential sales contract and the West Virginia jurisdictional. You will no longer have 2 forms, you will have 1 form. Now, the only thing that you will lose by merging those 2 documents, and it doesn't have to be a bad thing, is that if there was conflicting information, the jurisdictional took precedence. You will lose that when we merge those 2 documents. Okay? But the document will stand on its own. Your broker will have a broker council meeting on July 14th. Please encourage your broker to attend that meeting so that they'll get the unveiling of the documents that's going to be uploaded.
Hey Margie, what time is that on July 14th?
I don't think we
My
have
broker's
time.
right there, so I'm good.
Dale, come on, you guys come up here.
She just sent out an
Maybe they
email.
can get to talk because Dave was here. Come on, Dale, come tell them what's good about today.
It's 12 o'clock.
How's everybody?
12 to 2.
Just sent out an email.
Thank you for lunch.
Florida.
I'm selecting.